Mediation is a process in family law that is an informal settlement conference in which the parties come together to try to narrow the issues for purposes of a trial, or to come to settlement to where you don't have to go to court and go through the trial and the presentation of the evidence in a open and public setting. So mediation would be private. For the most part, you're not allowed to bring anyone, although if you have perhaps a business, or you have a expert witness who has done a custody evaluation of the party's child, where the child would be placed, or a forensic exam of the state, then that expert may be permitted to go. Professionals usually are permitted to go, but your other lay witnesses, teachers that would testify in trial, you generally don't bring those folks to mediation. Now, in Harris County and Fort Bend County, all 13 of the courts will require mediation before a final trial, and the majority of the 13 courts will require mediation before a temporary orders hearing on child custody. So the courts will maintain a list of mediators that they will randomly choose mediators from if the parties cannot agree to a mediator. In Harris County, you have the Domestic Relations Office and the Dispute Resolution Center, which are free but fee-based. At the Dispute Resolution Center, you have attorney volunteers. At the Domestic Relations Office, you have staff, which is about 3 attorneys, and the other 5 are social workers. Now, I've used the DRO for years, and I don't have problems with using those folks, and if they give me non-attorneys, I generally am fine with that. But as a caveat, if you have a non-lawyer who is trying to settle y'all's differences, the non-lawyers do not present evidence at trial. They've never been to trial other than maybe sitting on a jury or watching a trial. And so, as they've not done that, and they're not, their study is primarily on relationships, and they will try to bring the parties together as far as trying to either divorce them as friends, or trying to get them to move on to a new relationship when their relationship terminates, to where there's some form of peace and a conclusion which is not bitter and hateful. But at the same time, the when it's a dog eat dog dissolution, and one party has really done the other party wrong, and it's you have contributed years to a relationship and you want something out of it, then that's where you need a sharp lawyer who is familiar with the law and can trace out assets, or advocate your position as to your child, as to why you should be primary or why you should have certain rights. Now, in Fort Bend County, you have the Fort Bend County Domestic Relations Center, which is $50, but if you go above a certain threshold on your income, combined income, then they would disqualify you. You have to pay for a mediator. The average cost of a mediator is $350 to $450. That's basically a consumer type case. The lowest I've seen is $250, and then they go up from there. The highest is $900. Former judge in Harris County, was a fine judge and is a fine mediator, and he would take on primarily very complex cases. The 250, I mean, I've used the former judge, the current Judge Stolder, as a mediator. She's a board certified attorney. Now she's a judge, and I used her for years, and that's all she charged. So I was very happy with her. But you'll have to call around on the judge's list to get fees, and generally you're going to be hard. It's not going to be easy to find a board certified attorney for less than $400 to mediate your case. And like I said, the average cost is $350 to $450, and that would be a lawyer with 5 to 10 years out who has tried a couple cases, and that's not unusual for that amount to be charged. Most of your mediators will mediate Monday through Friday from 9 to 5. although in my eyes, the biggest consumer mediator is Jane Joseph, who does mediate 6 to 10. She basically mediates 3 mediations a day, Monday through Thursday, and then she'll do some weekends on an occasion, but I believe that's usual with her. And if you would like to mediate on the weekend or during the evening, then that is not normal, and so that may also result in a premium or an extra charge. But what I found is when I have clients with unusual schedules, I go to there's a social media group in Harris County, on Facebook, in which is Harris County and the surrounding counties. You can find mediators. There's several hundred lawyers in there, and then several dozen mediators. So it may be you want a mediator like in Brazoria County, and Brazoria County is one of the former judges down there is who I would go to. But you may want to shop around because he costs too much, and so you would post that in the social group, and then you would get feelers as to who's the right fit for you. Now, preparing for mediation, you really need to have your documents there and be prepared to have a discussion. Like it would be like you're going to trial, but the presentation of evidence would not be. It would be informal, so it would not be through a question and answer where you have objections, but you would necessarily want to bring an inventory of all your assets coupled with the supporting documents to the inventory, the current bank statements, the current retirement statements, the mortgage statement, if the property's separate property, the deed that shows it's separate property. You need to bring all that with you, because the other side may say, well, I don't know, we were living together and we bought the house, and I thought that, we filed taxes together that year, so I think we're common law married. So as you don't know these things, it's better to bring it all there to prove your case. With your child, if you have children, you're going to need, more likely than not, you're going to need the school records. You're going to need any health records, any records on if there's been some issues with mental health, some acting out, those counseling records, those recommendations. Many times you have young children who you have the mother who is watching the children primarily, dad works, and the kid will have a mouthful of cavities. With some judges at work, when mom says, I should be primary because I've had the kid the whole time, and then the judge says, yeah, but the kid's got 30 cavities, so that means you haven't really been watching the child, pushing sugar on them, and not brushing their teeth. And so that's evidence of a real bad start for a child, as far as, if you can't keep their teeth up, who's to say that kid is, going to pass kindergarten, right? You can't fail kindergarten in Texas. But my point is that the evidence that you would have for your trial, but for your witnesses, you would bring to mediation. Now, in my case, I am successful in about 65% of my mediations, and another 20% of those that I would not be successful at mediation, I settle on the courthouse steps, because then I get my witnesses. I already have my paperwork. I bring my witnesses down there and we work it out. So some mediators get on me because when I go to mediation, I generally make them kind of hard, and they want me to be less rigid. But it's like it's all or nothing. Many times, is your client wants the best for them, and as they want the best for them, that means being prepared. And so if the other side's not prepared, then it's like, why are we here? And we took the time to come here. We did all this paperwork, and I go to mediation all the time. The other side doesn't have an inventory. They allege that the other side is not doing the things that they say they're doing, but we bring school records, we bring things to the mediation which create an inference that our position is a good position, and the other side brings oral accusations of that their case is right and that the judge is going to give them everything, and then, okay, well, let's go to trial. And then a couple weeks later, we settle on the courthouse steps. because they're still not ready. And then, and a good 65% of them we settle. And then out of that, there's another a fair amount that we end up taking to trial. Now, if you sign a mediated settlement agreement, it's very hard to set it aside. While it's possible to set it aside, it is difficult. I posted 2 cases here, the in Ray Stephanie Lee and the Minix case. Both of these cases, one from the Texas Supreme Court, one from the Houston Region Court of Appeals, that is within the last 3 years. You can't sign a mediated settlement agreement and come back in 3 days and say I was bullied into it. You have to have specific family violence, and that family violence event scared you such that you signed off on this agreement, which is what in Ray Stephanie Lee holds. And then even in the Minix case, where it had been a couple months and they had a MSA, mediated settlement agreement on temporary orders, the Court of Appeals said you need to enter that mediated settlement agreement first as judgment before you go and modify anything. And so it's not easy to set aside mediated settlement agreements. I mean, it's possible, but it's not easy. So as it's not easy, I get all the time folks come in and they say, I don't like it, I don't want to do it. And, and then I start asking questions. Well, did you have an inventory you went to mediation? No. Who is your lawyer? This is my lawyer. And I'm like, well, you had a lawyer. You may not have done your paperwork that you should have, but that's what you got. So is that's what you got. For me to set it aside would be fantastical. And the side that represented your significant other, if I know that lawyer, I'm going to say, that lawyer is going to be prepared at an evidentiary hearing and you're going to lose. Sometimes you can file it and get a little more out of the, you'll get some room for negotiation, but it's not advisable once you sign one to try to set it aside